Mr. Grime, am I saying your name right?
You are, Senator.
You argued the Calais case?
I did.
Okay. I'm going to tell you my understanding of the case. And then, Mr. Cox, I'm going to ask you to tell me if Mr. Grime got it right. And Mr. Chamberlain, you can chime in if you would like. Are you familiar, Mr. Grime, with the Students for Fair Admissions case?
I am.
Okay, that's the case recently where the Supreme Court said you can't use race in college admissions. Now, here's what I heard the Supreme Court say in that case. I heard the Supreme Court say, look, colleges, we're not going to get into the admissions business. That's your business. We're just telling you you can't use race as a factor to admit anybody. Is that your understanding of the case?
Basically, yes. And they did a whole 14th Amendment.
Don't try to muddy the water to make it look deep, guys. I know you're all smart. I'm just trying to get to the bottom line. Am I wrong or right?
You're right.
Okay. Now, the way I read Calais is the Supreme Court is saying, look, first of all, these are political questions. And we're not going to tell the states how to draw congressional districts. We don't want to be in that business. That's a political question. We're just saying you can't use race as a factor. Is that what they did in Calais, or am I misunderstanding it?
That's basically it. You can use it to remedy, past discrimination that you've proven. But that wasn't the case in the Calais case. The other side didn't prove it.
Well, but once again, you're muddying that water, man. Did the court, or did it not, say that you can't use race to draw a congressional district?
In most cases, you can't unless the state, the person defending the map, shows that they had to use it because there was a showing of immediately past intentional discrimination, that they had to use race to unwind.
Okay.
Yeah.
Tell me whether he got it right, Mr. Cox.
Senator, quite frankly, the defense of the Calais case is such a tortured exercise. It's
Mr.
difficult.
Cox, I don't want to hear.
So I'm going to tell you what
how
SFFA applies to Calais.
Did he get it right, or
he did not get it
wrong?
right? Okay. So in under application to discuss Calais, you have to really discuss what happened in the case that created the district that was challenged in Calais. That was Robinson.
Right.
The court required the state of Louisiana to redraw its plans pursuant to its
Cox,
findings of a Section 2 violation.
Look, I don't
That's
want to
what
have a fight.
justified the creation of the plan.
I don't want to have a fight. Can you just tell me, and you're smart, and I don't want to make this more complicated than it is. Tell me what he got right or wrong.
I'm telling you, what he got wrong was ignoring...
No, you're speaking like a lawyer, okay? And I'm tired of... I've listened to you gentlemen, okay? Let's just get down to it. Mr. Chamberlain, tell me what Mr. Grime got right or wrong.
He got it all right. You think I'm really going to tell the guy who argued and won Calais that he didn't understand what he was arguing?
Okay.
Sorry, no, I'm totally respectful. He obviously, I think he's got a good handle on it.
I understand that, Mr. Cox. I don't mean to be rude, the importance of precedent and all that. But didn't the Supreme Court say, except in very narrow circumstances, you just can't use race to help a person, and you can't use race to harm a person? And that includes in drawing congressional districts.
In answering that question, I'm going to tell you that the Robinson Court, which gave rise to the district that was challenged in Calais, said that there was a violation of the Voting Rights Act, that it was required to draw a district or draw a redistricting plan that satisfied the Voting Rights Act, that allowed African Americans to elect candidates of choice.
You don't want to answer my question, do you,
challenged.
Mr. Cox?
I'm answering your question.
No, you're not.
Maybe an answer that you don't like and my colleagues don't.
No, you're not.
But I'm answering your question.
You're giving us another lecture, and this is not a common law class. Tell me in simple terms, is that not what the court said?
The court said a lot of things that were inaccurate. So that court said you can't use race at all in drawing plans. We disagree with that. But what the court really did was say that you can prove race you can prove there was intentional discrimination, which is in violation of this Congress's intent. It also sprinkled partisanship as a defense for any challenge to under Section 2.
All right, well, I'm about out of time. I can see no disrespect, Mr. Cox, but you're not answering any of my questions. And I know you're disappointed in the decision. But let me put it another way. Do you think race should be used to help a person?
I don't understand that question. Race should be used to
a
help
person? Do you think race should be used to help a person?
I believe that if there is a racial violation of the law, that race discrimination, I believe a remedy that's race conscious can be required, yes.
Do you think race should be used to harm a person?
I don't really understand what that question means.
No, I didn't think you would. Mr. Chamberlain, do you think it's fair in America to use race to help a person at the expense of other races?
No.
do you think it's fair in America to use race to hurt another person?
No.
How about you, Mr. Graham?
Absolutely not. Race should not be used to help or hurt an individual.
And no disrespect to Mr. Cox. He's very bright. I can see that. And I've been where you've been. You know, when you get in front of a court of appeal and you're losing, you know, you want to kind of obfuscate. I get it. But that to me is what the court's saying here in all these cases. We're not going to try to run your business. Not in college admissions, not in drawn districts. But you can't use race. Period. End of discussion. And I think that's what the Constitution says and what most Americans support. I know you're disappointed, Mr. Cox.
I'm not disappointed. I'm outraged.
But that's what the Constitution says.
Well, can I add one more thing that's
Sure.
not quite exactly addressing what you asked? I do think there's a role for a co-equal branch of government, Congress, to make its own determination regarding how it wants its laws enforced. And I would urge this Congress to reconsider Calais in that light.
Yeah, but you and I are both aware that the United States Supreme Court has full authority to pass on the constitutionality of a statute. Come on, you know that. I'm sorry, Mr. Chairman.
If Mobile versus Bolden is any example of what can and can't happen, this Congress can take a look at Calais and say, actually, you got it wrong. And you actually didn't interpret what we intended the United States to correctly.
The problem with your argument is I don't think race should be used to help a person because of his race. And I don't think race should be used to harm a person because of his or her race. And I think that's what most Americans believe.
And
Now, if you don't believe the opposite, and you clearly do, this is America. You can believe what you want. But the Supreme Court is deciding these cases.
I hear
and
you.
saying race is off the table.
I hear you. And I believe as a civil rights lawyer that if you find a violation based on race, you need to craft a remedy that addresses that.
Sure.
This hearing was ostensibly about congressional redistricting and Supreme Court precedent. But underneath the legal terminology and procedural arguments was a much deeper national conflict, whether the Constitution should permit race-conscious remedies to address discrimination, or whether any use of race by government institutions is inherently unconstitutional. Senator John Kennedy approached the hearing with a strategy he often uses in contentious legal debates: strip away technical language and force witnesses into giving simple moral or constitutional answers. Almost immediately, Kennedy framed the Supreme Court's recent rulings, including the Students for Fair Admissions College admissions decision and the Louisiana congressional redistricting case, as part of a single broader constitutional principle. Government should not use race to help or harm anyone. That framing matters because it reflects one of the central legal shifts currently happening inside the Supreme Court. For decades, courts often permitted certain race-conscious policies under narrow constitutional frameworks involving diversity goals or remedies for discrimination. But the modern court has increasingly moved toward a stricter interpretation suggesting that race-based governmental decision-making is constitutionally suspect almost regardless of intent. Kennedy clearly aligned himself with that interpretation. He repeatedly attempted to simplify the debate into plain language questions. Should race ever be used to help someone? Should race ever be used to harm someone? Should race factor into congressional district maps? Witnesses like Todd A. Cox resisted those simplifications. And that resistance became the central tension of the hearing. Cox repeatedly argued that the redistricting case could not be separated from the history of Voting Rights Act enforcement and prior findings of racial discrimination in Louisiana's electoral maps. His broader point appeared to be this: race-conscious remedies are sometimes necessary precisely because racial discrimination itself historically shaped political systems. That is a foundational argument in modern civil rights law. Under that view, pretending race never existed in systems built through racial exclusion can itself perpetuate inequality. Therefore, limited race-conscious remedies may be necessary to enforce equal voting rights protections. Kennedy rejected that framework almost entirely. What made the hearing especially revealing was not just the legal disagreement, but the clash in communication styles. Cox spoke like a civil rights litigator, emphasizing precedent, historical context, statutory interpretation, and institutional complexity. Kennedy repeatedly interrupted that approach and demanded direct yes or no answers. At one point, Kennedy openly accused the witnesses of muddying the water and obfuscating the issue. That exchange reflected something much larger happening in American politics. Growing public frustration with highly technical legal arguments surrounding race, representation, and constitutional interpretation. Supporters of Kennedy's position often argue the Constitution requires equal treatment without racial distinctions, race-conscious systems inevitably create unfairness, and modern America should move toward formally race-neutral governance. Supporters of Cox's position argue race-neutral language can still preserve racially unequal outcomes, historical discrimination has ongoing structural consequences, and civil rights protection sometimes require race-conscious enforcement mechanisms. That is not merely a partisan disagreement. It is one of the deepest constitutional and philosophical disputes in modern American law. The hearing also exposed an important political reality about Supreme Court decisions. Kennedy framed recent rulings as straightforward and obvious. The court is simply saying race should not be used by government. Cox argued something very different. That the court was ignoring congressional intent behind the Voting Rights Act and weakening long-standing civil rights protections. That distinction matters enormously. Because Supreme Court rulings do not end political debates, they often intensify them. And in this case, the court's evolving approach to race-conscious policies is reshaping college admissions, congressional districting, voting rights enforcement, diversity initiatives, and potentially many other areas of public policy. One of the most revealing moments came near the end of the exchange. Kennedy distilled his entire argument into a single statement. I don't think race should be used to help a person because of his race. And I don't think race should be used to harm a person because of his or her race. That line is politically powerful because it sounds morally intuitive and universally applicable. But Cox's response reflected the central counterargument of modern civil rights law. If racial discrimination created unequal systems, remedies addressing those inequalities may necessarily involve race-conscious solutions. And that is where the hearing ultimately landed. Not on technical legal doctrine, but on two fundamentally different visions of equality itself. One vision argues equality means government must become entirely race-neutral. The other argues equality sometimes requires acknowledging race in order to remedy discrimination and protect representation. The Supreme Court is increasingly siding with the first approach. But the political and legal fight over that shift is far from over. In fact, since these rulings, debates over voting maps, affirmative action, and diversity programs have only intensified across multiple states and federal courts, with civil rights organizations continuing to challenge district maps and lawmakers pushing new legislation tied to voting representation and equal protection doctrine. And that means hearings like this are not simply about one court case. They are about the future definition of equality under the Constitution itself. What do you think? Should government institutions ever use race-conscious remedies to address discrimination and representation issues, or should the Constitution require fully race-neutral policies in all circumstances? Leave your thoughts in the comments below. And if you value long-form congressional analysis that breaks down the constitutional, political, and historical battles shaping Washington, subscribe to Capitol Oversight for more deep oversight coverage and hearing breakdowns.